Okay, we'll call the meeting back to order, and our next special permit request is 095-17, Atamian at 7 Uncatina North in West Falmouth, a special permit to construct a pool and a hot tub, increasing lot coverage to over 20%.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Massachusetts General Laws, you are hereby notified that Reed R. Atamian of North Falmouth, Massachusetts, applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-69E of the Code of Falmouth to allow a pool and hot tub exceeding 20% lot coverage by structures on subject property known as 7 Uncatina North, West Falmouth, Massachusetts. And for referrals, engineering had its standard comment. Concom note stormwater must be contained in property through gutters to dry wells and drainage features. Water will come across road over to coastal bank. Fire department had no comment, and assessors not applicable. Planning, no comment. And that's it.
Okay.
Good evening, Mr.
Bob.
Chairman, members of the board. For the record, my name is Kevin Clower. I'm an attorney with Ahmet Clower Law Firm here in Falmouth, and I represent the applicant Reed R. Atamian, the owner of 7 Uncatina North. This property is located in the Cliffs subdivision, at the corner of Cliff Road and Uncatina North in West Falmouth, just south of Old Silver Beach. The lot has just shy of 18,000 square feet at 17,978 square feet in the residential B zoning district. Though we're not here about the dwelling tonight, the dwelling is a almost or recently completed 5-bedroom home with a footprint of approximately 3,500 square feet. It's conforming as to front, rear, and side yard setbacks, as well as to lot coverage by structure and lot coverage by structures, paving, and parking. In the process of developing this property, the applicant made the determination that he'd like to add a hot tub and a pool to the site. This would add a total of 385 square feet, which isn't much, but it nudges us up from 19.98% to 21.81%, thereby requiring a special permit under Section 240-69E of the zoning bylaw. This provision in the bylaw allows the Zoning Board of Appeals to issue a special permit for lot coverage exceeding 25% but below, exceeding 20% but below 25%. And in doing so, the board is asked to consider the size and height of the structure with regards to the average size and height of structures in the neighborhood, the effects of shadow on adjacent properties, the impacts on views and vistas from public ways, the effects of nitrogen on coastal embayments. This is a bit of a unique application in that the structure that I'm permitting, or we're seeking to permit today, doesn't have a height. It's a pool. That's the trigger for the special permit. So while this is a structure as defined by the bylaw, it's not necessarily a structure as envisioned by this particular bylaw. The dwelling is an entirely by right structure on the site, and the pool is really the only issue relative to the special permit. In speaking to the standards, the pool will have no impact on the size and height of the dwelling with relation to the size and height of dwellings in the neighborhood. There's no effect of shadow on adjacent properties. There's no impact to views and vistas from public ways, and there is no effect of nitrogen on the coastal embayments. We did prepare a lot coverage spreadsheet that was submitted to the board this week. We did not include gross building area in this, again, because the pool doesn't have any gross building area as envisioned by the bylaw. But I did note that a number of the surrounding properties have similarly sized footprints and/or lot coverages by structures. So for these reasons, I believe that the dwelling, or the lot rather, both as existing and proposed, is within the appropriate range to qualify for a special permit under this provision. The proposal is not substantially more detrimental than what currently exists. There are no adverse effects. There's no new nonconformity. There's no public view or vista that will be impaired, and it meets the standards of 240-216. Therefore, I would ask that the board grant a special permit this evening, and I'd be happy to address any questions you might have at this time.
Okay, let's see if Robert has a question.
No questions.
No questions.
I don't have it.
Kim?
Pretty straightforward.
There's always room for questions.
Is there?
There is. Where will the pool equipment be kept?
It's going to be located on the existing concrete pads close on the southerly side of the house, or the southeasterly side of the house.
Where it says like AC, is
Yep,
that?
yep.
Okay. All right. And then obviously the patio doesn't contribute to the lot coverage?
That's correct.
Okay. What material is that proposed?
I believe it's bluestone.
And then could you address the comment regarding drainage? Is there any concern as to this?
No. I mean, we don't have any drainage off the pool. To the extent the pool is drained, it'll be handled appropriately within the terms of however they do those things.
Okay.
We're not creating any water runoff from the pool, though.
And then the fencing, that's what's in the file, was submitted that?
Yep, it's a black chain link fence that'll be 5 feet in height with gates that open outward. And it'll enclose the entirety of the backyard, as shown on the plan.
Okay, that's all I have.
Anything, TJ?
Kim asked one of my questions, so I'm all set.
I'm all set.
I have no question, well, the only question I have is, are they gonna use the hot tub in the winter?
I don't know.
I'm wondering, I like them in the winter, but, okay.
Snow, hot tub, snow, I get it.
Exactly. No questions. Any comments or questions from the public on this? If there are none, we can close the hearing.
I will move to close.
Second it?
Okay, Kim and Ed, all in favor?
Aye.
And I will move to approve.
Okay. Any findings?
I think
You
we
want a
need-
second?
Oh,
I'll second.
Yeah, okay, good. Kim and TJ,
Well, I will say, it's not adding any bulk or anything like that.
Can't be seen from the roadway.
Can't be seen from the roadway.
there's 3 structures listed that are, actually have higher lot coverage in this lot coverage calculation sheet that they gave us.
It's in full compliance of 240-16?
For 216,
16, is that what I said?
yeah.
In 240-3C.
That's not applicable.
No, 243C is not before the board.
Right.
240-69E
E,
meets all the requirements of 240-69E.
yes.
And I'll go through the list of those.
And that they're putting in a bluestone patio. So that does not contribute
To what?
to lot coverage by structures.
Yeah.
Okay?
Okay.
Condition, what does that say? Build it like the drawing.
Further drawings, right?
Okay. Is that it? All in favor?
Aye.
Aye.
Thank you very much.
Okay, well,
Good night.
Night.
Yep. Good night.
Thank you.
All right, so our last public hearing is 098-17, Reposa, 307 Old Barnstable Road in East Falmouth. Special permit to allow for an existing accessory apartment within a detached structure.
Being all persons deemed affected by the Board of Appeals under Section 11 of Chapter 40A of the Massachusetts General Laws, you are hereby notified that John P. and Diane L. Reposa of East Falmouth, Massachusetts, applied to the Zoning Board of Appeals for a special permit pursuant to Section 240-38I of the Code of Falmouth to allow for an existing accessory apartment within the detached accessory structure barn on subject property known as 307 Old Barnstable Road, East Falmouth, Massachusetts. Let me see here. For referrals, engineering had standard comment. Assessors had no comment. Fire department had no comment. Planning, applicant filed a site plan review application and will be on the November 28th planning board agenda. I believe that we had further correspondence from the planning board.
Site plan approval.
Site plan approval, thank you, Suri. Dated December 13th that we just received today, December 14th in our office. And Concom had no comment, and that was it.
Okay? And for the applicant.
Yes, I'm John Reposa, and I'm the one that's I'm trying to get this through. So I don't know what you need from me now. You have it in front of you.
Why don't you give us a little of the history and I can explain, give us a little of the history and explain the situation.
That was a barn that's been there since the mid-'70s. And my father's a carpenter, he's the one that constructed the thing. So what I'm doing is it's gonna be an apartment now with my family, actually.
So has it been used as an apartment
Yes.
previously?
Yes, yeah, it is, actually. They're in there now, my daughter. She had no place to go, so that's where they ended up.
Okay. Sari, any other pertinent information that we should?
It meets the criteria of the new bylaw
Okay.
with the 40%, the 800 square feet. The floor plans are in the file. There's been no correspondence.
Okay.
Board of Health is okay with it? You can't.
Pardon me?
Board of Health is okay with it? For nitrogen?
They didn't submit a referral,
They-
and they have to sign off before there's occupancy, so it's up to them at that point.
Okay.
It's not our purview right now.
So it's, I guess, it's an existing subsurface disposal system,
Yes,
and it's been sized appropriately.
yes, I actually had it inspected from an inspector, and that's fine. Title V inspector. I have it with me, matter of fact.
Do we need it?
No, keep it and let the Board of Health review it when you go to
Yes.
get a sign off by them.
Yeah.
Again, it's not our purview.
Okay.
And Sri, you said you checked that all of these requirements are satisfied in terms of him living
And
on the property?
as well as the
and-
planning board, yes. They are year-round residents. And they understand the monitoring to the building commissioner that they have to do every year to let them know that they reside there 7 months out of every year. I did explain that to Mr.
So
Raposa.
that's, you're good with all of those
Oh, I'm not going
requirements?
away.
And in the apartment right now, there's a kitchen? One bedroom, is it?
Upstairs, it was kind of narrow because of the
Pitch of the
because
roof.
of the knee walls,
Right.
the space. That's what really narrowed it down.
So how many bedrooms is that?
One.
One.
Okay. Any other questions from the board?
Not here.
No.
Any comments or concerns in the public about this project? Okay. We've heard everything we need to hear. We could close it. Paul, you want to make a motion?
I'd like to make a motion to close the hearing.
No second.
Okay, all in favor?
Aye.
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 Okay. Anybody want to make a motion
Well,
to approve
Yeah, I
or
guess.
discuss?
Sri, I just have a question for you.
Uh-huh.
I know we already closed, so I think that's okay. Does the calculation take into account the unfinished storage space, or is that not considered part of that?
The unfinished storage does not count.
Okay. Yeah, it seems like that's going to be an issue that was an issue in our last accessory dwelling too, that it only takes up a certain portion of the accessory structure, and then you kind of have this extra space. Okay,
But the thing is, this is unfinished, the other is not.
right, yes. I'll move to approve the application.
Second.
And I would, for findings, I think 24838I. Really all we talked about. Yeah, and that will include that he lives there year-round, and the size
Yeah,
satisfies the
I'll
requirements.
set forth all the requirements in there as findings.
He's using, well, it's for, really being used for family right now.
Testimony is, but
Testimony.
you don't want to
Right.
hold him to that.
No, I don't, but testimony to that effect. And that's, Can we say it's legalized, or, no, I guess we're not going to.
You can make a finding that you acknowledge and accept it as an accessory apartment
Okay.
based on the bylaw.
Okay.
So you want to do a finding on that?
Yeah.
Yes, what you just said.
You have all the right words.
Well, actually, the testimony is that the prior use was all for family, which I think would have made it legal before, right?
No.
No?
It's detached, remember?
Oh, because it's detached. Okay, are we, any further
Oh,
discussion?
conditions would be per plans and in accordance with 24038I.
Sounds good. All right, all in favor?
Aye.
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 And aye. Okay, you're legal. Thank you for coming to us.
Thank you very much.
Yep.
So that was a vote, did they take a vote on that? They called the vote?
Okay, that brings us to the
Does anybody else have plans, or is that an open meeting?
open meeting. The first item on the open meeting agenda was the minutes of December 7th. 1941.
This is my-
Oh, okay, yeah.
Anyone?
Move to approve?
Minutes.
Yeah,
What minutes?
I just said that.
Yeah, but did you say if everyone's had a chance?
Has everyone, oh, you want me to say that part?
Yeah.
Has everyone had a chance to look at?
Yes,
and
I
review
did.
the minutes?
Yes.
Yes.
Any corrections or additions?
No.
Okay, then let's have a movement to approve them.
Make a motion to approve the minutes of December 7th.
Second.
Okay, all in favor?
Aye.
Okay, they're approved. Unanimous. Then there's a board determination on insubstantial change regarding the transfer of the Village at Old Main 40B Project 95-15 comprehensive permit.
And I'm recusing from this.
Okay.
This is, previously, the board approved this, I believe, in 2015. It is called Village at Old Main, 8 units, ownership. Mr. Greg Young is here from Northland Residential Corporation. The previous owner, Mike Salamondo, is proposing to convey the comprehensive permit to Northland Residential Corporation. It is up to this board to make a determination under 760 CMR 5604 something, that the board has to determine whether the conveyance is substantial. If the board determines that, you go for a public hearing. If the board determines it is insubstantial, it's an automatic grant of the conveyance. This has been on the table, and I have also emailed it to all the board members. It's a letter from Mass Housing Finance regarding Mr. Young's proposal and the conveyance. There's information in there on Northland Residential Corporation, and he is here to answer any questions
Okay.
the board so
Yep.
has
Do
any.
you want to come forward and make a brief?
Bless you.
Yes, good evening. My name is Greg Young. I'm the Manager of Acquisitions and Development for Northland Residential. I'm here with Sean Scahill, who's in the front row. He's the Northland's Construction Manager, and also Attorney Paul Glenn. I'm here to request the board approve the transfer of the comprehensive permit for the Village at Old Main project in North Falmouth from the original applicant to a new limited dividend entity controlled by Northland. As the board might know, the project received a comprehensive permit from the board in January 2016, which is still valid. The project has not been constructed yet. Northland has the property under agreement and plans to build the approved project.
I believe all of the board was here for the hearings in 2015 and 2016. But I'll just give you a very quick refresher on the project. The applicant was Mike Salamando, the Village at Old Main LLC. Due to personal reasons, Mike sought to locate a reputable and qualified and financially capable developer to assume the rights and responsibilities of the permit. As was mentioned, the project's located at 41 Old Main Road in North Falmouth, right near the North Falmouth Elementary School, and it abuts the bike path to the east. It consists of 2 affordable units out of the 8 units. They'll all be for sale units. You have an existing home up front on Old Main Street that will be rehabbed, and then you'll have 3 duplex buildings that will be constructed at the rear of the site, and there'll be a new single-family home constructed up front on Old Main Street. That was the plan the board approved in January 2016. The permit does contain a condition that the comprehensive permit shall not be transferred to a person or entity other than the applicant without the written approval of the board. And DHCD regulations state that prior to substantial completion of a project, a comprehensive permit may be transferred to a person or entity other than the applicant upon written confirmation from the subsidizing agency that the transferee meets the requirements of 760 CMR 56.041 A and B, and upon written notice to the board. As Sari mentioned, there was a letter there from Mass Housing that we received this week stating that that we meet the requirements to be the transferee. Just to give you a very brief background on who Northland is, we were established in 1970. We're based out of Concord, Massachusetts. We're primarily a developer of for-sale empty nester townhome communities. We have about 30 employees. Our Upper Cape projects over the years included Rand's Harbor and North Falmouth. We developed 6 waterfront lots there. Stratford Ponds Phase 2 in Mashpee, we built 94 empty nester townhomes. And more recently, the villages at Brookside Golf Course in Pocasset, we developed 242 empty nester townhomes there. Our 40B experience includes just recently in Duxbury, a 40-unit for-sale townhome development consisting of 30 market rate units and 10 affordable units. Construction began in 2013 and was completed in 2016. The cost examination for the project has been certified by Mass Housing. And right now we also have a project underway in the approvals process, a 44-unit for-sale townhome development that will be permitted under the comprehensive permit that was just applied in September for project eligibility approval. We're very excited about moving this project forward. We have connections to the area. Sean lives year-round in Falmouth. My parents live year-round in Falmouth. And Jack Dolly, who's the Northland's president and CEO, his in-laws live in Katamet, and Jack sits on the board of directors for Cape Cod 5. So we're very excited to be taking over the project. I met this afternoon with Falmouth Housing Trust, and they're also excited to see the project move forward. They'll be serving as a monitoring agent for the project. On December 15th, Northland requested in a letter that the board issue written approval of transfer of the permit from Village at Old Main LLC to a new limited dividend entity formed and controlled by Northland, as is required by Condition 9 of the comprehensive permit. This new entity will be Shining Sea NRC LLC that Northland has formed. We respectfully request that the board include in its approval a statement that the transfer does not constitute a substantial change pursuant to 760 CMR 56.0511. Just in closing, not sure how on top of DHCD regulations the board is. The regulations state that the board has 20 days from the December 5th notification to determine and notify Northland whether it deems the request to be substantial or insubstantial change. Thank you, and I'd be happy to answer any questions.
Okay. Any questions?
No, I don't have any.
One question, are you gonna build it just like the drawings that were approved?
Correct.
Okay. I guess, what's the feeling of the board?
I have no objection to it.
I don't
To the
have any
conveyance
objection.
map, sounds fine.
Seems to be insubstantial according to the regulations.
Yeah, I would agree. So we could, I guess, entertain a motion that this is deemed insubstantial?
You make a motion that it's insubstantial and direct me to write a letter of approval based on the DHCD requirements.
Okay.
That's what we did. I saw my move.
Actually, let's see, so do I need I need 5 for this, so
Oh,
I need to appoint someone. So
This is an open meeting, so you can,
have
This
just a
is-
general vote?
yeah,
Okay,
I believe so.
okay.
It's open meeting, not a public hearing.
All right, so anyone is free to make a motion to that effect?
I'll make the motion.
Okay.
I'll second it.
Okay, so Ed and Paul, that we instruct Suri we deem this an insubstantial change to the comprehensive permit, and instruct Suri to write a letter stating that in accordance with the DHCD guidelines.
760 CMR,
Yeah.
560511.
Yeah.
I was wrong before.
All in favor?
Aye.
And aye.
Thank you.
Off you go.
Boy, you've never done that.
Yes, you can. Except that I think I just.
I'm free to go.
Okay.
No.
My agenda.
You say goodbye, you hand it over to TJ.
Oh, right, I'm done. That's right, because the next thing I'm not on, so. Right, so there you go. TJ will take over.
Thank you, Mr. Chair.
Good night.
Two to one appeals, Medway and Bagley. I'm sorry, TJ, I should have got the files for you.
Okay, so next we have open meeting agenda number 3, board discussion regarding the appeals Midway Trap and Skeet 67-17 and Bagley 68-17 for possible decision. I just want to remind the public that the hearing has closed. This is an open meeting agenda item for the board, so there'll be no more public comment taken at this time. Also, please refrain from making any remarks in the crowd. And again, this is just purely for board discussion and a possible vote tonight concerning the 2 appeals. In previous hearings, we did take both appeals. We heard them both the same together. But for tonight, I think it's best to address both appeals separately and possibly draft a decision tonight.
Make a
And-
decision,
Make a decision.
unless you want to draft it.
No. I defer to you for that, sir. I think it would be wise to take Bagley 68-17 under consideration first. Bagley, that was the appeal of the building commissioner's determination of the zoning violation and also the request that the cease and desist order should be extended to the rifle range. All that having been said, we can turn it to board discussion.
You want to start it?
Would anyone want to start?
Attorney George mentioned toward the end of the first meeting we had, and at the end of the second one, about Mass General Law, Chapter 214, Section 7B. I don't know if you all had a chance to read that.
Yes.
I did, yes.
Which makes me wonder, this is pretty much cut and dried, appears to me. I'm not a lawyer, but it is, I think as Attorney George said at the end of the last meeting, that the gun club is protected from the noise complaints under this chapter in verses of law. So it seems to me that there's not an issue here.
Well, would we want to discuss it a little bit? I agree with you on, this seems straightforward, but if we just relied on this and there was an exception to this, we may miss something. I mean, the Attorney George submitted it. I think the rules of the game were that it was forwarded to Attorney Amott, but he didn't have a chance, or he can't respond.
It was discussed at previous hearings.
Yes, and we have not.
It was a month ago, whatever it was.
Yeah.
Yeah, no, I know, I sort of agree with you. I mean, I was leaning to the conclusion anyways that we should grant, I think it's grant the building commissioners.
No. In this, you would
In the
vote-
rifle
In
range.
this, you would deny the appeal.
Deny the-
Or approve the appeal.
Deny the
But
appeal.
does the board want to talk on some of the findings that they made based on it, like the testimony of the
Okay.
rifle range itself? I mean, you
Well-
got to make good findings.
Well, that's what I sort of was, I mean, I think the rifle range has clearly been there. It predates the date of the zoning requirements. What I found interesting was that, well, no, this goes to the pistol range, but at the time, there was testimony that there's no change in impacts to the neighborhood since the pistol range was closed. When they were using the pistol and rifle range together. I found that interesting. I think there's a woods there, and the development occurred around the woods. As the houses were built, the lots were cleared, roadway was cleared. It is my assertion that the sound, or the perceived sound, would increase, but we don't know what the sound was before the houses were there, so we don't know if it's increased or decreased, but it probably would increase because there's less buffer from the trees in the woodlands. The vegetation attenuates sound. The rifle range is below, it's depressed, so that would somewhat suppress sound.
Should we go through the, I mean, if we're going to deny it, and there's a bunch of reasons in the,
Well, I'm not,
14
I
pages,
suggest
isn't
that the board discuss
Yeah, that's
the
what-
testimonies that was made,
Right.
the aerial photos that you saw, relative strictly to this is the rifle range only you are discussing, not the pistol range.
There was testimony and affidavits that were submitted.
Right.
And some very strong affidavits on the side of the club.
right.
Stating what?
Stating that the range had previously existed, and that there was some cleanup or manicuring of the range. The aerials showed the range back in 1970. And I would also tend to support the building commissioner that it shouldn't be extended.
That was the pistol range, not the rifle
As
range.
far as the rifle range is concerned, I think there's two main things here that we need to address.
No, I mean extended, they want to extend they're asking to extend the cease and desist order to the rifle range.
Oh, right, okay. I see
Yeah,
what
so,
you're saying.
what I'm saying is
Right,
that
and
it
the
shouldn't,
building
it shouldn't
commissioner.
extend to the rifle
Yeah.
range because it was pre-existing, there's been enough
Right.
testimony, and there's been aerial photos. And the affidavits that were submitted were stronger than what you'd see in a normal affidavit.
Oh, yeah.
So we do have MGL 214, Section 7B, which does afford midway protection.
That gives them
And-
protection, yeah,
and
protection on the noise.
We do need to address that. The rifle range is a pre-existing nonconformity that existed before, I believe the year was 1971. We do have the building commissioner's testimony during the November 16th hearing, and he said, I don't want to directly quote him, but he said that in all the documentation and photographs, there was clearly a rifle range in 1970, and so in good conscience, he couldn't issue a cease and desist order to extend to the rifle range. And there were a number of affidavits, like you said. Let's see, there was John R. Augusta III, his affidavit stating that he shot at the long rifle range with his father as early as 1965. There was also Michael D'Souza's affidavit. He stated that his late father and others shot rifles at the range, and that they were also acknowledging improvements such as the backdrop to the range itself. There were other affidavits. I think it was John David Augusta's, Daniel Pimentel Sr., and Robert H. Walker III.
Mike Rabiza, Mike Gavigan, Mike McCarthy, Eric Peterson.
I think we should acknowledge, too, that they have a safety officer, and there's been no safety complaints that we know of. Some people express concern about safety, but with no complaints and the safety officer, I don't think safety was an issue. There was one gentleman with a health issue that appeared to be pre-existing when the person moved there, and notwithstanding this general law, I think his testimony was that it aggravated his condition, but it didn't cause the condition, and didn't hear any testimony per se to say that in itself would be a reason, notwithstanding the general law, that we should deny it. I mean, there were a lot of people opposed to it because of noise and things like that, and I think I had sympathy, not sympathy, I understand what they're saying, but I do think, the general law is clear, if I'm reading it correct, and they moved in around the existing rifle range. The affidavit that was filed with some of the deeds, and is a notice of the notice that there was some concern with, that the attorney that drafted it might have omitted something, a notice, and that they did not intend, but I think both attorneys said that was an item of fact, but not necessarily something we would determine in front of us. It was just a notice of intent. It wasn't binding on the gun club or the trapping ski club.
There's also been no increase in membership.
Yes, yeah.
And the membership is also limited to 125, I think.
I think those are findings about the
Yeah.
membership. Right now, you're trying to determine
But I think it
the
leads
rifle
to,
range. You might want to reread Attorney Alment's appeal and get the facts so that you can make findings on those. You want to take just a minute? I think it's important that you stick to the rifle range right now. A lot of the information that was just discussed was relative primarily to the pistol range. There was very little testimony on the rifle range, if I remember correctly.
Well, there's continuation. People have been shooting there.
They all talked about the whole thing.
But we had, okay, we'll go back to.
It got a little confusing, so that's why I'm asking you to reread the appeal, so you can see specifically what you're determining. It's tough when you hear both of them together, because a lot of the testimony is together and hard to separate, if you will.
I think it's the letter dated September 21st. I think it was alleged that it substantially expanded after March 1st, 1971, and therefore needed a special. Wait a minute, that's a pistol? That was a pistol range.
The second paragraph, pretty much, you know, in the order the building commissioner addressed, blah, blah, blah. Bagley and some 44 other neighbors, collectively the complainants, to 284. In the request for enforcement, the complainants averred that Midway's rifle range and pistol range violate the zoning bylaw in the absence of an authorizing special permit from the ZBA. In the order, the building commissioner determined that Midway's pistol range should not have been constructed without a special permit. He ordered Midway to cease operation of the pistol, and on that same premise, he's asking appellant submit that the rifle range was developed and/or substantially expanded after Midway's use of its premises became a conforming use in 71. Was there testimony given or information, documentation submitted showing that the rifle range had changed after 71? The appellant submit that the rifle range, like the pistol range, violates the zoning bylaw in the absence of an authorization of a special permit.
There was confusion as to, not confusion, differences of opinion as to the length of the rifle range.
Right.
And if the last recorded length, I think it was Attorney Amott was saying that it was a large increase over the existing rifle range. I didn't find that particularly.
He said it was less than half.
Less, yeah, it was substantial. But, you know, for a rifle range, I don't know if I'd consider that a significant change, based on the fact that it's a rifle range. If they were going automatic weapons, that might be one thing. But, you know, it's a rifle range, and even before I read this court case, that didn't significantly influence me.
The aerial photos didn't show enough consistency that there was an extension of the range.
Aerial photos like a Bible. You can get anything out of them you want to. And, you know, I don't mean to be disrespectful, but they were confusing, subject to interpretation. We had the testimony of Mr. Woolley, was it, who did some measurements on the ground that seemed to more substantiate than aerial interpretations. Not that they can be wrong, but GIS and aerial interpretations, I think, subsumed by someone on the ground taking measurements.
And to add to that, there were affidavits and there was testimony from club members that, you know, basically the basic upkeep of the rifle range, they would
It was more of a
I don't have it
manicure.
written down here.
It was more of a manicure. It was more
Right,
of
they would-
a
they
manicure
would
and
clear
cleanup
the-
versus a street expansion.
Rifle range, when I went out there, was clearly like it, you know, it might have been changed, but you couldn't tell it from large disturbance in the range itself. You know, the berm, other than the new berm on the left. So, I mean, it's, and there was a court order to put in the backstops.
No, it wasn't a court order.
No.
Oh, DEP.
The Mass
DEP.
DEP suggested it.
And
Miss-
that's what
That's more of a
triggered.
separation.
Yeah, Mr. Werlo stated that there's basically minimal, if any, change. And he was the one who has inspected the property for years on behalf of the USDA. So,
But I thought, thank you, sir, but didn't the DEP order go, they had to put a backstop in for both because of lead?
I remember it strictly for the pistol.
It's
but-
for the pistol
Yeah.
range.
It was recommended that they do that,
Well, lead is
and they
lead.
did.
Okay, Ed, anybody? Do you guys have any comments, additions to make,
Yeah.
findings, anything?
Is that enough, do you think, to make this,
I haven't heard a lot.
yeah?
I don't know which way you guys are going, so it's hard for me to say, but whichever way you're going, you need to discuss it, agree to it, and make findings based on your
I
determination.
think we're going the fact that we think the rifle range should,
Pre-existing.
Yeah,
We're focusing on Bagley right now.
Yeah, that's the
Should-
rifle
Should the
range.
cease and desist order extend to the rifle range?
and I think the answer is clearly no, or no. It should not extend to the rifle range.
The affidavit supported that it existed prior
Correct.
to that 1970 date.
right.
The aerial photos were ambiguous, but in most cases, through testimony, it seemed that it was more of a manicuring or a clearing
As you said.
versus a lengthening
Right.
of the range.
Correct.
So I gather you guys are getting enough information together to deny the appeal?
Yeah,
To deny the appeal and
Yes.
support.
So
The
you want to
building
make
commissioner.
findings on the denial?
Yes, I do. If you wanted to poll the members.
And basically, you just said a good one. What the one finding was?
Yeah, so
Based on
through testimony and affidavits,
Mhm.
it was shown that it previously existed, the rifle range.
Previously existed to when?
It's that date, 1970.
1970?
yeah.
Okay.
But had been manicured or debris had been cleaned up, not lengthened. There were aerial photos submitted
But not lengthened. Okay.
showing the placement of the rifle range, which also supports its existence. Then, according to that Mass General Law that was submitted, they have protection.
Do we have to discuss or not discuss the notice of prevention of easement?
The what?
I know Attorney George didn't think it was binding, and I thought, Attorney, I'm not, sort of addressed the same thing, and I was thinking that's a matter to go in front of the courts. The attorney that drafted it's no longer available.
The building commissioner's decision was based on the fact that it pre-existed. So if we have enough evidence to show that it's pre-existed, there's also a, substantiation on the Mass General laws that protect the issues on the noise. I don't know how much further we have to go than that. I mean,
Mass General Law pretty much covers it.
and there was the aerial photos that showed the previous existence.
I guess I'm not disagreeing
No, I
with
just
you.
don't know what else we need to, I mean, if you can think of something else that you need to add.
So we don't think the notice of intent, I don't know why I keep on forgetting that term, of notice of prevention of easement is significant for the rifle range. I think it's a legal matter that's not before us, if it was attached to a deed, but, you know, we can leave it out this one and put it in the other one.
Do you have a copy of that?
The notice of, well, I think it came down to the language that they intended to use the ranges, and they did not specify in later notices that it was going to be used as a pistol range. But I think,
But I think that's going, that's going to the pistol range again. It's not,
you're right. I take that, you're right. Okay. I have to hear my own voice sometimes. Well, why don't we,
did you
I
have
trust
any
we could
additions,
have
or-
Let's go through the chair.
Sariq to draft it as best she can.
I
and
have
get it back
until
to
a
us.
certain date.
Okay, what's that date?
I believe it's January 25th, where it has to be filed with the town clerk at that time.
Okay, so you draft it and you send it out for review by both sides?
No, if I draft it, you have to make a public motion.
Oh, I think we're there to make a public motion for you to draft it. I mean, I don't know if we need any
If you
more
guys are ready to
discussion.
make a determination and you've
Yeah.
made your findings, then you make your decision. I'll draft the document.
Okay.
And like every other permit that I do, I send it to you
Right.
to see if you're okay with it. If you are, then I get it signed and submit it to the town
I
clerk.
thought you also sent it to the appellants and the opponents.
Special permits, I do, yes.
Oh, okay, that's what I was, okay.
But not this.
It's up to you guys. I mean, it's an appeal, you're going in the motion of denying it. You're going the way of denying it, not in the motion, excuse me. Out of courtesy, would I send it to Attorney Ahmet? Is that what you're asking me? Most likely, yes, and Attorney George.
Yeah. And at that point, it would just be for factual information, not necessarily,
Or
not just to make
grammatical,
a
grammatical
grammatical.
corrections, you know.
so then I guess I would make the motion to deny the Bagley appeal.
I'll second it.
Okay, that was the motion made by Bob, second by Ed. All those in favor?
Aye.
Aye.
All right, so your findings are what is stated,
Yeah.
basically,
Yep.
Yes, what we previously discussed.
which I've got 4 findings.
You want to tell us what they were again?
It's the,
You can read them.
Okay, I just, in case we missed something.
If I missed it, you guys missed it.
Well, you might have missed it. No, I don't mean to be quibbling, I think we got.
Okay, so up next, we have, this would be Midway's 67-17. And this would be the cease and desist order against the club for the pistol range. Does anyone want to start us off?
well, this one I'm a little more conflicted on. You know, according to the building commissioner, there was evidence that there was some kind of a modification. And without anything lacking, that, without anything stating, affidavits, et cetera, that existed.
I'm sorry, Bob, say that again.
Well, we didn't have really any testimony that clearly stated that that pistol range existed the way it is now. There was a creation of the backstop and the berm, but it was to be in compliance, I guess, with the suggestions of Mass DEP,
And that was in 2001?
14.
2014.
Was the
I'm
pistol-
sorry?
2014.
14, I
14.
apologize.
But the pistol range was there when they inspected it. Because that's what they were improving, that's why they had to put in a berm. I mean,
Well, it seemed like they were doing a separation.
Say again?
Seemed like they were doing a separation
Well, it could
from
be
the...
for safety reasons.
So I can understand them needing to do it, and I would think they would want to do it for separation, but it is a modification.
But it was there before.
It clearly was there before. People said they were firing there before.
And there was also people that said, where Rod Palmer said that the earth looked like it had been fairly recent, but there was testimony that it had been that way for years. Just because it kept falling away, and it wasn't fresh.
So if you do the modification of the berm and the backstop, do you consider that a significant modification? I think it's something that they should have done, it was allowed. I think it's something that they could apply for to extend the use. But I didn't see any clear evidence that showed that it wasn't a modification.
It was an improvement.
Did you find that testimony was given that the pistol range existed prior to 1971?
I think somebody said
Yes,
that.
a number
yes.
of people had said it.
All right, now
Yeah.
look at what the building commissioner is saying. Did the building commissioner,
Building commissioner said that because he received complaints, he went out there and he observed the pistol range, and I think it's clear there was construction or recent activity. The left-hand side was clear that earth had been moved. But he could not say what impact was occurring beforehand, because he wasn't there when the woods were there and the houses came around. It was sort of like, well, I got complaints, I saw some improvements were made for DEP, therefore I concluded it was a substantial change. He didn't know how much the firing was, whether it was a significant increase in firing.
Well, that's my question. Was there enough evidence that supported that there was
I don't think so. I mean,
a range, no, that range was there?
clearly the range was there. Your question.
No, the
The
pistol
pistol
range.
range, if putting in the backstop was a substantial change that needed
He
a
said I
special
could
permit.
include the pistol range, as it looks like it was either created or enhanced. And somebody else said it had been there for a long time, which
Right.
meant it was being enhanced.
he said, I don't know, but I don't believe that it was in the 1970. I don't think that these berms would look the way they do if they were in existence in the 70s. I can't clearly say when they were created or when the pistol range was created, but I don't think that it was 1970. I would say it was created within the last 5 to 10 years. I have read a lot of documentation that was submitted, and many of the affidavits contradict each other. Which ones are accurate? I don't know. The earth berm vegetation and other dynamics is how I came to my conclusion that the pistol range was not there in 1970. And then he said it's challenging to look at the photos and determine if there was a pistol range there. Possibly there was, and maybe they've changed on the site, but it would still require a special permit. And what he's saying is to extend or alter, because it's a pre-existing non-conforming use.
But if that was true, then the rifle range, which was extended,
The rifle range, I think the key is the date.
You just determined
I know.
in
we
your
just
last
determined it.
decision
You've got
that
to,
the rifle range did not substantially change, that it may or may not have grown 5 feet
I don't
based on
think-
Werlos.
I don't think, considering this was a rifle range, this was a substantial change. They didn't increase the number of firing ports. I mean, if you could get 3 or 4 people side by side.
but did you see anything regarding that pistol range being there, again, in that 1970 date? I think that's what we get stuck on, is that date.
I think it has changed, at least because of putting in the safety backstops.
Well,
and
that's
the
what I
berm.
mean. Well, so one is a manicured clearing, one is an installation or an expansion.
I guess we agree to disagree on that, and then we have the general law that just said that,
So if we base on the date, because
The
it's,
general law doesn't have anything to do with pre-existing,
No, it has to
altering
do
a
with
pre-existing non-conforming use.
Okay.
Mr. Palmer said, there are 2 appeals on the case, on the cease and desist, which was based on my decision, including the rifle range. There was clearly a rifle range in the photos from 1970. It may have been lengthened. For me to analyze the photos from 1970 and now, I don't know what the length was. In good conscience, I could not include the rifle range in my cease and desist. I could include the pistol range, as it looks like it was either created or enhanced. So what he's saying is that whatever changes, if it was created or whether there was a change in it, required a special permit, which was not applied for. And that's what he's saying. And that's under pre-existing non-conforming.
I guess I still don't think, I disagree with the building commissioner, there was a substantial change.
So if you just start with the date, the 1970 date, what have you seen through the testimony of the file?
That there's
That
an
supports,
existing rifle
that,
range.
no, that supports that the pistol range where it is now was there in 1970.
Testimony of the members.
Which testimony in the file?
Oh,
Do you know which? I mean, I'm not putting you
I
on the
think
spot. I'm
they
just
all
trying
said
to.
they're fired, I think it's there, we can go back and
I mean,
dig it out.
if you look at the old aerials, you can't really see anything. They're ambiguous.
Well,
And if you go on some of the testimony regarding the creation of the berms and the backstop, those were well after 1970. I think they would have been eligible, and still would, if they made an application to extend use to include the pistol range. There was Mass DEP, suggestions that that's what you should do safety-wise.
correct.
They just didn't do it at the time. They did the approving. They just didn't apply for the special permit.
But the building commissioner himself said, all but for the noise complaints, he wouldn't have gone out there, or may not have concluded. It was the noise complaints which the
Well,
general law.
So that gets him to site. So now you're on site, and there was a noise, but so now you're there. Now you have to find some reason showing that that portion existed there back in 1970.
I think
He said, I don't know what the conditions of the site were before the berm was created or what there was for vegetation. I don't know if modifying the topography of the earth would cause the noise to increase. The creation of that berm and the removal of the vegetation could have increased the noise level for the neighbors. I would have sent Midway to the zoning board to look at the proposed earth berm. So he's saying back then, if they had come to him, he would have sent them for a special permit.
Okay, that's what, okay, and I disagree with him in that reduce vegetation and the elevation of the rifle range, okay?
Rifle and
is-
pistol range.
Pistol would not have increased the sound. And if anything, it would have
But
deadened the sound.
he's saying, and this is where Bob is saying, he went out there because of the noise, and that's why I just read you. Either way, he would have sent them because it's a change or possible extension of that pistol. He said, what I meant to say was the modification to that site, pistol area, trees had to be removed, and maybe that they were screening the noise. I don't know what the pre-existing conditions were. If the applicant had come to ask if there would be any permits needed, I would have sent them for a special permit. So just in the clearing and changing is what he is saying.
And I guess I am disagreeing with him. Well, Bob and I have been going back and forth, maybe we can hear from some other
Well, yeah,
members.
I think everybody should join in this discussion. Talking what Rod Palmer said in those two areas.
I have a feeling that pistol range has been there for a long time. Just from testimony, that's what I was looking for, can't seem to locate it, but I thought somebody said that several people had said that the pistol range had been there for a while.
But Bob's saying they altered the pistol range, therefore, which, in the building commissioner's opinion, it needed a special permit.
I think the whole thing is based on altering
Yeah.
the range. I understand the noise, but the noise issues, again, I think would still be protected. I mean, the Mass General law.
What the commissioner was making his determination on was strictly the
Was just
alteration of the
the
land
site.
to change what may or may not have been existing in his mind as a pistol range.
Right.
He stated in there, he can't tell when it was created. There was very little testimony on the
There
pistol.
was some testimony at one point about pistols, but I think it was a combination with the actual rifle range.
I'm not sure, I read the same thing. Mr. Chairman, what do you think?
So, I mean, obviously, this is the tougher issue to decide. There is less evidence regarding the pistol range compared to the rifle range, and there was testimony that there was pistol use out there, but as opposed to the actual range itself, we do have the building commissioner that said that he went out there and witnessed the berm and the backstop that was suggested by the DEP. There's one thing to consider. Attorney George's letter, which was, let's see here, I think it was his May 15th letter, page 5 and 6. He quoted Derby Refining, which cited Cape Resorts Hotel, Inc. versus the Alcohol Licensing Board of Falmouth, which is coincidentally. And it said, quote, "Valid non-conforming use does not lose that status merely because it is improved and made more efficient, provided, however, that the changes are ordinarily and reasonably adapted to the original use and do not constitute a change in the original nature and purpose of the undertaking." So, I mean, his whole argument is that the berms may have been installed, but it was merely just to improve the range. And we do have the backstops, which also constitute an improvement, but they were done at the request of the Mass DEP.
And I would think that if the Mass DEP had suggested you put the backstops in, there was something there before that
Right.
needed improvement.
Yeah, that's what I was
The
trying to
question
allude to
is,
before.
was it before 1970?
What was before?
But again, what you've got to get back to is the building commissioner's determination. And what you guys have to find, which either way you go, is the aerials, the testimony. I mean, you're focusing, it's not up to you to disagree with the commissioner.
Okay.
It's up to you guys to make findings to either uphold or overturn the appeal strictly for the pistol range. Did you find enough information that it existed?
Yes.
Do you agree with the building commissioner? Those are the things that you've got to focus on. Go back to your aerials, go back to the testimony. And I agree with Bob, there was very little on the pistol range itself, because that was something that Attorney George pretty much set forward. So you got to go back to his testimony, affidavits, and aerials.
Do I get to make a comment about that?
No.
Because it isn't true.
No.
It isn't true.
Excuse me?
No
Come on,
This is board discussion only.
we have the minutes.
Yeah.
Well, I'll be a little bit more blunt. How many votes does it take if it's?
You got to
3
have
or
a
4?
unanimous vote.
It has to be unanimous.
You bet.
Okay.
You bet. So if you guys aren't prepared for this one, we can make another open meeting. I think this is an important issue to go back and read everything. You've made your
I think so.
determination on the rifle range.
Okay,
The pistol range, you seem to,
that's fair.
I think I know where you want to go, but you've got to have good findings to either uphold or overturn. And you're all agreeing on maybe 1 or 2 findings, but I don't necessarily know that's enough.
To support.
Well, it wouldn't hurt to continue the pistol range, in my opinion.
So we could
But-
go back and review what we got in the files.
Dig through the files.
Yeah,
Yeah, and focus strictly on that now.
yes.
And I know it was confusing for both of them being together. I understand that. But I think you need to start from the beginning and read Attorney George's submission of the appeal, and then go back and forth with the 2 attorneys, and then your testimony. Look at your minutes on the testimony on the pistol range only. And any affidavits, whether there were or not.
And you're saying focus on if there was a change to the physical conditions of the pistol.
I'm not
range.
telling you what to say.
No, but you're suggesting, because every time.
I've read to you what the building
Yeah,
commissioner
Yeah.
stated. That's all I did. And it's up to you guys to find what you find. Was the pistol range there? Do you, and if you do believe that, then go through that file and get findings. That'll
I think that's fair for
substantiate
I think we have
that.
to do that.
So do we continue this?
Make a motion
and
to
then
continue.
approve the other one?
You did approve the other one.
Oh, the other
already.
one?
We already
Okay,
voted
that's
on the
done.
other appeal.
Do you want to reschedule? Again, remember, the timing is short here, so you might have to even go through it and meet. Is it January 25th? On the front of that, or the waiver will tell you on the inside as
waiver.
well. Where's my,
Can we request,
January 15th is.
January
the waiver's
15th, oh my
extended.
can we
God.
request an extension of the waiver? Deadline?
It's closed, the hearing's closed. I don't know if I can
So
do
the
that
answer
or
is no.
not. I don't know, because the hearing's closed.
So what do we have for
I'm
available
not sure.
dates?
You guys, can you meet next week or the 28th? You can meet, since there's
Wait,
only
next
4 of you,
week's-
we can meet at
what's the date
4:30.
next week?
Yeah,
The 28th, that'll still give me time.
28th of December?
Yep.
I'll be out of town.
How about the 21st,
But,
which is next week?
next Thursday.
yeah,
Would that give you guys enough time?
and we could meet earlier. I
Yeah.
think most of us could meet earlier.
Yeah.
You want to say 4:30?
If that's okay with you guys, this will be an open meeting once again.
No, that's fair. I just want to make,
And maybe by then I'll be able to have that, I don't know, how many decisions did I have to do tonight? 3? Wow.
does 4:30 seem like it's more than enough time? We could move it up to 5, but.
Hello?
I think 4:30 is a little early.
Okay, yeah, I just,
No,
No,
4:30 is all
I
right.
just
with me.
wanted them to,
Yeah.
yeah,
Yeah.
Bob, what do you think?
you and I
I
aren't
can do
working.
4:30. I
You can do
trust that.
4:30?
Can you do, you're the chair?
We can do 4:30 then.
all right, then I'll schedule an open meeting for next week, and please review and try not to, I'm confused just by sitting here and trying to read the minutes and everything else. It is confusing.
Someone make that motion?
I'll make the motion to continue this to the 21st of
Reschedule the
December.
decision, yeah. The close,
4:30?
at an open meeting of the board.
I'll second.
So us four can open it since we're the only ones voting.
It's an open meeting, yes.
Motion was made by Ed, second by Bob. All those in favor?
Aye.
Aye.
Mr. Chairman, you have to close the night.
Sorry?
Do your gavel.
All right. Procedural rules and policies, I guess we'll pass on that. Any future agenda items?
Not right now, and I don't want any more.
All right. We're done for tonight.